Good day, ladies and gentlemen. Welcome back to another What If video. My name is Viep here, and as always, it is great to have you. Today's topic is what if an employee makes inappropriate or offensive comments on social media? Now, with social media being an integral part of the daily lives of so many people, one issue that employers may face more often these days is that of employees who badmouth their managers, clients, colleagues, or the work environment in general on social media sites. What we also see is not necessarily these comments or posts being directed at the employer directly, but making offensive or derogatory comments or posts in general, but these posts being seen by the public as unacceptable. For example, sexist or racist comments being made. The question is whether employers are entitled to take disciplinary action against employees who do this. Now, it may be argued that, provided that it is done in the employee's own time and in a private capacity, that the participation by employees on social media sites falls outside of the employment relationship and that employers are therefore barred from taking disciplinary action against them. In terms of case law dealing with misconduct that took place or takes place outside the working or the workplace or working hours, way back in 1993, the Labour Appeal Court in the matter of Hust versus the Chemical Workers Industrial Union held that the fact that misconduct occurred away from the workplace does not necessarily preclude an employer from disciplining an employee in respect thereof. The court said that the test is whether the employee's conduct had the effect of destroying or seriously damaging the relationship of the employer and the employee. So the line between private activities and the work environment is sometimes a very thin one, as we know. The reason for that is just as the individual has the right to privacy, so does an employer have the right to protect its business interests. And because of this, employees are not free to do and say what they like when they are away from work. Employees who, for example, make these derogatory remarks about the employer may, apart from possible civil liability, also be faced with legitimate disciplinary action. Now, this can happen, for example, where the employee's remarks have an actual or a potential negative impact on the employment relationship, workplace relations, or the business of the employer in general. In other words, if you as the employer can prove that there's a causal link or a nexus between the employee's conduct outside of the working environment and, for example, the employer's business interest, the employee's conduct is no longer merely private but may lead to appropriate disciplinary measures or action being taken. Now, we've drafted a couple of or list of factors to be taken into account in assessing whether social media conduct amounts to misconduct. Please note that this list is not exhaustive, but will definitely serve as a guideline for you to consider in the future in determining whether disciplinary action can be taken. So the factors are the following. One, the nature and severity of the comments made by the employee must be taken into account. The subject matter of the comments, the actual or potential damage caused to the reputation of the employer, whether the confidentiality of the employer has been breached, whether the employer has a social media policy in place, and whether the employees have been trained on that policy, whether the misconduct is in breach of the ethics expected from an employee, whether the employee's comments were made during working hours and or using the employer's equipment, whether there was a public outcry over the post and whether the outcry was reasonable, whether there are any other mitigating factors, whether the employee who made the negative remarks holds a position of trust within the business, and finally, whether the employee's conduct created a serious breach of trust between the employee and the employer. So to conclude, ladies and gentlemen, what employees communicate to the outside world, outside of the work environment and outside working hours, is therefore not necessarily a purely private matter as many people believe the case to be. Our advice is that employers amend their disciplinary policies, if you have not done so, to include a provision that any derogatory or negative statement made by employees outside of the work environment, for example such as on social media sites, could result in disciplinary action being instituted, which might, in appropriate circumstances, also lead to dismissal. A word of caution, however, employers should keep in mind that some level of criticism of and comment about the employer or work colleagues is part and parcel of the employee's right to privacy and freedom of speech, and that not every negative statement will necessarily lead to action, especially dismissal. As is the case with all instances of misconduct, each case must be evaluated on its own merits before action is taken. Now that brings us to the end of this video. As always, thank you for watching. We hope to see you soon. Until next time, bye-bye.